This video's explanations are condensed from CoinMarketCapitalization. Now review the XRP deadline that the New York State Department of Financial Services has extended. The New York State Department of Financial Services has extended its deadline to rule on James Murphy's administrative appeal of the department's refusal to produce any documents about the exclusion of the XRP token from the green list. Before we move any further, please kindly support our channel by pressing the subscribe and notification bell. Murphy is a legal expert at Low Street Advisors. He made this revelation on XWatch, formerly known as Twitter. Murphy is attempting to overturn the department's decision to remove the XRP token from the approved list through his appeal. Murphy finds it confusing that the New York Department of Financial Services decided to DST XRP following the court's ruling. The legal analyst is curious as to the rationale behind the decision to remove the token associated with Ripple, and given that the cryptocurrency secondary sales did not qualify as a security offering while this was happening, and Ethereum has managed to maintain its spot on the department's greenlit despite its issues with regulatory bodies. Murphy complained earlier this month, alleging that the New York Department of Finance and Security had refused to provide even a single document in response to his request for freedom of information. Murphy is now urging the government to provide adequate transparency, as in the unlikely event that his appeal is denied, the attorney plans to file a lawsuit. The voluntary production of those records by the New York Department of Food and Safety, in addition, Litecoin TA UK Jetcoin discovered that they were not included on the green list Ripples. At that time, the list of tokens that had been pre-approved for placement on exchanges was withdrawn, and XRP was removed from it. The government agency's instructions regarding the listing and delisting of digital currencies were modified in October of last year. The only cryptocurrency asset that can boast regulatory certainty is XRP, as Chief Legal Officer Stuart Allen RI recently pointed out. This comes after the company won a partial battle with the U.S. Securities and Exchange Commission the year prior, but there were no updates regarding. In the case of SEC CV, Ripple, which investors may want to review as part of the court's briefing schedule, the Securities and Exchange Commission (SEC) was required to submit its opening brief regarding remedies by March 22nd. The opening brief discusses the verdict that will be rendered in July 2023 regarding the selling of XRP to institutional investors. Judge Annalisa Torres' decision determined that Ripple had violated Section 5 of the 1933 Securities Act by selling unregistered securities to institutional investors. On March 26th, a redacted version of the opening brief will be made available to the public. The CC would probably have recommended a substantial penalty to deter. The speech that Gary Gensler, the chair of the Securities and Exchange Commission, gave at a Columbia Law School conference coincided with the filing of the lawsuit. Towards the end of a prepared speech, Gensler discussed the cryptocurrency market and the necessity of registering with the Securities and Exchange Commission. When there is no registration, there is no obligation to disclose that the cryptocurrency markets could benefit from a little disinfection.